Good morning. My name's Dean Reuter. I'm with the Federalist Society. Welcome. We've got a great day planned for you today. We will begin in a moment with our panel on diversity jurisdiction. But before I turn things over to our panel, I want to apologize for what has been described to me as the bus debacle last night. I hear some knowing laughs, so some of you are involved in this. Not everyone is aware of what transpired. Even I don't know how many buses were involved, but apparently on the way back from the Marriott Marquis last night, after a splendid evening with Justice Alito, some of our guests were encouraged to board one or more shuttle buses to return to the Mayflower. Some of those guests were told the ride would be free, only to find that once they had boarded the bus and settled in, that they were charged for their return ride. So I wanted to both apologize for the misadventure and assure you that those buses were not authorized by the Federalist Society. They were not Federalist Society shuttles. In fact, I suspect that this might have been a rather lame attempt at fundraising by a rival organization. But we're still gathering facts. And for all I know, one of the buses is still circulating here somewhere. So if you're here with us this morning, you are among the lucky, believe it or not. But on behalf of the Federalist Society, sincerely, I apologize for any inconvenience. Turning to our panel on diversity jurisdiction, let's assume that some of our bus riders from last night got together and want to sue the bus company. I'm just assuming this. I'm not promoting it. Now, our guests, of course, come from all over the country. As I'm sure you know, the bus company, assuming it was a company at all, probably a D.C., Virginia, or Maryland company, where would our riders file suit? And could the bus company remove the suit to a federal court? Should they be able to? Our panel this morning includes 3 Federalist Society regulars. We've asked Judge Edith Jones to act as a participating moderator. So she will keep time, lead the discussion, but we're also going to enjoy the benefit of hearing her views on the topic. All 3 are extremely well known to us and to our audience. So with that, Judge Jones.
Thank you. Good morning, and thank you all for getting up early after having a late night last night. Very fine event, but it's hard to wake up if you're from west of here. You all know Judge Wilkinson from the 4th Circuit. You know me from the 5th Circuit. To some extent, we owe our positions to the man on my left, Chuck Cooper, who was the Assistant Attorney General for the Office of Legal Counsel at the time our nominations went through. It proves that we're all not millennials at this point in time. Chuck has had a very distinguished career in practice and in government. He clerked on the 11th Circuit for Judge Paul Roney. He started out in government with the Civil Rights Division of the Department of Justice in '81. After he became head of OLC, he worked there until 1988. He's been in private practice since then, founded his own firm, Cooper & Kirk, in 1996, is a trial and appellate lawyer in cases involving constitutional, civil rights, administrative, and healthcare law, among other things. I won't go on further, but pertinent to our discussion today, he was a member of the Standing Committee on Rules of Practice and Procedure of the Judicial Conference of the United States. Now, you may ask, what does diversity jurisdiction have to do with millennials and intergenerational equity? And I have to admit, some people may be here because you think diversity had to do with the civil rights movement. Well, this is in essence civil rights as far as some of us are concerned, civil rights for litigants. But I paused a bit thinking about this relevance myself and came up with the following. To me, the debate over diversity jurisdiction, before I set forth, advocacy views on the subject, the debate really has to do with the rule of law. The rule of law embodies a number of different elements. It involves generality and application. It involves fair procedures, transparency, intelligibility, which means people can understand what the law is, and finally, democratic accountability. It is my view that the challenge of the millennial generation is going to be to restore the rule of law in the United States of America. We have had a period of incredible prosperity, incredible challenges worldwide, and therefore incredible growth of the federal government and indeed government at every level. And at some point there seems to be a tipping where government begins to consider itself the master rather than the promoter of freedom, which is what the Federalist Society stands for. So consider this subject as one element of the debate going forward, where our generation is going to leave to the next generation a lot of problems to solve, and one of those problems is how to accommodate the demands of justice in a changing society. And with that, I will turn the program over to Chuck Cooper.
Well, good morning, ladies and gentlemen, and thank you very much, Judge Jones. It's a real pleasure and privilege for me to be here this morning alongside Judge Jones and Judge Wilkinson, two genuinely towering figures in our federal judiciary. And to whatever extent, Judge Jones, that I had anything to do with that back in the Reagan administration, it was really the best day's work I ever did. And I have to also say, whenever I see Judge Jones, I can't help it. My mind goes back to 1990. And I think to myself, George H.W., this we shall never forgive. It is also always great fun to be with my old friend and my former colleague in the Reagan administration, our days from the Civil Rights Division, Judge J. Wilkinson. The doctrine of complete diversity was established in the earliest days of the Republic. It dates back to 1806. But in modern times, it has been used strategically by the plaintiff's bar as an instrument to close the federal courts to large-scale interstate disputes, such as mass tort actions, but other actions as well, and to herd those cases into carefully selected, very notoriously often plaintiff-friendly state court forums. The requirement of complete diversity enables plaintiffs to do that by the simple expedient of naming as a defendant a citizen of any state in which any plaintiff resides. Now, Howard Nielsen, my partner, and I recently wrote an article in the Harvard Journal of Law and Public Policy called Complete Diversity in the Closing of the Federal Courts, in which we examined the history of the framing and the ratification of Article 3 and of the history of the doctrine of complete diversity. And I want to make full disclosure, that article grew out of a study that we were engaged to do by a client that was a nationwide victim of this practice by the plaintiff's bar of herding cases. They had hundreds of cases in concentrated in several select state court jurisdictions in this country, where by very careful empirical data, they calculated the value of those cases was many, many times more than they would be based upon their studies if those cases were in diversity and diversity jurisdiction courts. As I think many of us know, that phenomenon has been a hugely costly phenomenon in commercial interstate businesses in this country. So the project also led to an effort that is undergoing right now, it's beginning, that we're involved in to seek legislative reforms of the diversity jurisdiction statute. So with that disclosure, I want to make 4 points this morning about complete diversity. First, the literal scope of the plain language of the diversity clause of Article 3, Section 2, which extends to controversies between citizens of different states, clearly embraces cases of minimal diversity. That is, cases in which any single plaintiff and any single defendant are citizens of different states. Second, the requirement of complete diversity is at war with the animating purpose of the diversity clause of Section 2. In fact, it's at war with one of the principal animating purposes of the creation of the federal judiciary itself, which was to extend federal jurisdiction, in Hamilton's words in number 80, to cases in which the state tribunals cannot be supposed to be impartial. Third, and most surprisingly to me anyway, as we dug into this subject, is that the requirement of complete diversity, which has restricted access to courts since 1806, even though it rests on an erroneous Supreme Court decision construing the diversity provision in the 1789 Judiciary Act, the initial diversity provision statutorily. In other words, the statutory requirement of complete diversity of citizenship is not one that the first Congress truly intended to impose on the federal judiciary in the first place. My fourth point, and it's a much closer and more controversial one than the others, is that the requirement of complete diversity may well be unconstitutional. That is, while no one doubts that complete diversity is not constitutionally compelled, and the Supreme Court has so held, it is not at all clear that the requirement of complete diversity is constitutionally permissible. So returning then again to the language of the diversity clause of Article 2, it is obviously satisfied whenever any plaintiff and any defendant are citizens of different states. And there's no hint that we could find anyway in the history of the framing and ratification of Article 3 that federal diversity jurisdiction it was thought that it would or that it should be limited to cases of complete diversity. To the contrary, the debates over Article 3, which were very vigorous and excited much opposition from the anti-federalists, almost invariably discussed the issue in terms of individual litigants. The Supreme Court has held, as I mentioned a moment ago, that complete diversity is not a constitutional requirement. That is, that Article 3, Section 2 is satisfied by a minimal diversity case. And it upheld that the federal interpleader statute establishing that proposition. Now, the records of the ratification debates are rich with statements of the purpose of the diversity jurisdiction. As Hamilton said in number 81, the prevalency of a local spirit may be found to disqualify the local tribunals for the jurisdiction of national causes. A local spirit. Well, it was a very polite, diplomatic way of putting his point. And he continued along these lines, elaborating. The national judiciary ought to preside in all cases in which one state or its citizens are opposed to another state or its citizens. For it is that tribunal which, having no local attachments, will be likely to be impartial between the different states and their citizens, and which, owing its official existence to the Union, will never be likely to feel any bias inauspicious to the principles on which it is founded. Well, let's put to the side, for this morning anyway, the debate over the accuracy of Hamilton's prediction concerning the national judiciary and focus just on his comments about the purpose of the diversity jurisdiction. Those sentiments were echoed by almost every major framer of Article 3, Section 2, every major supporter. Wilson in Pennsylvania, Marshall and Madison, of course, in the state of Virginia. Madison put the point in the Virginia ratifying conventions just a little bit more bluntly. It may happen that a strong prejudice may arise in some states against the citizens of others who may have claims against them. A citizen of another state might not chance to get justice in a state court, and at all events, he might think himself injured. So, after the ratification debates were over, and the Anti-Federalists brought their fight back into the first Congress, seeking constitutional amendments, some of which were designed to eliminate diversity jurisdiction altogether, and many of which were designed to restrict it in certain fashions, including with a constitutional amount in controversy. Still, the first Congress did exactly as everyone expected it to do if those constitutional amendments failed, as they did. And it enacted the Judiciary Act of 1789, including a diversity jurisdiction provision. This was, after all, again, the animating purpose of that provision, and one of the animating purposes of Article 3 altogether. To give you an idea how centrally important it wasn't until a century almost later that federal question jurisdiction was actually enacted by statute by the Congress. So where did this doctrine of complete diversity come from? Well, it came from a very perfunctory opinion, again authored in 1806 by Chief Justice Marshall himself. The court was interpreting that initial diversity provision in the Act of 1789. And its language was really closely similar to the diversity clause itself. The language was as follows. It extended federal jurisdiction to any suit between a citizen of a state where the suit is brought and a citizen of another state. Very, very simple statute, seemingly very clear. And the court, as I said, the opinion was perfunctory. This is it. It's 6 sentences long. One of the sentences is decree affirmed. And the money sentence is this. The court understands these expressions, these words I just read, to mean that each distinct interest should be represented by persons, all of whom are entitled to sue or may be sued in the federal courts. So, no analysis of the language or the history of the provision, certainly nothing dealing with the purpose of diversity in the first place. Just, what a strange interpretation of these words, suit between a citizen of a state, where the suit is brought, and a citizen of another state. It seemed on its face, I think certainly to any textualist anyway, that the case must be wrong. And in fact, it was wrong. Because the complete diversity rule of Strawbridge, which has governed federal judiciary, the federal judiciary and interstate litigants ever since, was acknowledged by the court to be wrong about almost 40 years after Strawbridge was decided. And it was acknowledged in a very interesting and I think remarkable passage from the Supreme Court, acknowledged on behalf of Chief Justice Marshall as well, even though he had died 9 years earlier. And the court, and it's so remarkable, I want to share the entire passage with you. I don't think I've seen anyway anything like it in any federal reporter, particularly the U.S. reports. And this is what the court said. It's a case called Letson. By no one was the correctness of Strawbridge more questioned than by the late Chief Justice who gave it. It is within the knowledge of several of us that he repeatedly expressed regret that that decision had been made, adding, whenever the subject was mentioned, that if the point of jurisdiction was an original one, the conclusion would be different. We think we may safely assert that a majority of the members of this court have at times partaken of the same regret. So you have a very remarkable passage in the Supreme Court dealing with internal deliberations of that court, including a deceased and but revered member of it, effectively confessing its error. One wonders if they weren't trying to send a message to the Congress, or perhaps to correct the court's own error, they being perhaps reticent to reverse anything that came from the pen of the great Chief Justice. But in any event, for whatever reason, it nonetheless is clear that complete diversity, ironically, particularly given the extent to which its purpose has been frustrated, the purpose of the diversity clause has been frustrated, was born in and admitted an avowed error of the Supreme Court. Yet it is governed for 200 years since. Look, I want to conclude very briefly, Madam Moderator, with really a quick observation that I think a very strong case can be made that a requirement of complete diversity cannot constitutionally be imposed by Congress, even if it were inclined specifically to do so. And that strong case has been made by a figure no less than Joseph Story in the Martin against the Hunters lessee case. The key point is that such a restriction on federal diversity jurisdiction is very hard to square with the plain language of Article 3, providing that the judicial power shall extend to controversies between citizens of different states, as well as the other enumerated cases and controversies, of course, and that the judicial power of the United States shall be vested in one Supreme Court and in congressionally established inferior courts. This is how Story read that language. The language of Article 3 throughout is manifestly designed to be mandatory upon the legislature. Its obligatory force is so imperative that Congress could not, without a violation of its duty, have refused to carry it into operation. Thank you.
Well, it's a great pleasure to be with this wonderful society today, and especially to be with my longtime friends, Chuck and Edith, whom I greatly admire. Chuck and I, in the Civil Rights Division together in the Reagan administration, we agree on a whole lot, but you won't guess that from what you're about to hear today. But simply put, that doing away with the rule of complete diversity, you don't want to do that. You don't want to sign on to a wholesale shift of power away from the states and into the hands of the federal courts, specifically the federal judiciary. I don't know how many cases abolishing the requirement of complete diversity would bring into federal court, but I know it would be a whole lot. And some years ago, a few years ago, I remember some of these debates over the Affordable Care Act, and the point was made that the federal government was one of limited powers. Article 1, Section 8 didn't allow regulations of decisions not to engage in commerce. And why was this argument made? It was made because the federal government was one of limited powers, and the residual powers in our system of government lay with the states. Well, there's an analogous argument to be made with respect to the federal judiciary. It's much the same with Article 3. Federal courts are courts of limited jurisdiction, the same way Congress is a legislative body with limited and enumerated powers. Once again, residual jurisdiction, that basic fund of police powers, lies with the states and with state courts. So I asked you to connect the dots if you take a limited view of Article 1, Section 8, and Congress's power, please don't just turn around and take a very expansive view of Article 3, Section 2, and federal judicial power. This will serve to build the authority of the federal judiciary. Eliminating the complete diversity requirement is going to give greater power over your lives to a growing constabulary of life tenured judges. When you open the door to minimal diversity, this is going to require a good many more federal judges. It's going to expand the size of the federal judiciary to hear this additional caseload. The judges won't just be hearing diversity cases. They'll be hearing a whole lot of different cases. And they're going to be handing down rulings in all sorts of subject matters, and many of those you're not going to like. And so I ask you, understand that when you open up a subject like this, you don't just get a single shot. One provision of the Judiciary Act changed, and federal judges confined to a single set of cases. You're doing something much, much more. So I ask you to stay balanced on this, because the present system provides, with the complete diversity requirement, it allows federal courts to make their contributions to state law, which I think is important in cases where complete diversity is present. And it gives us an acquaintance with honest-to-God lawsuits, where federal statutes and constitutional provisions are not present. But the requirement of complete diversity, that's the linchpin of state final say over questions of state law. That's what Erie was talking about. And if you have all kinds of minimal diversity coming into federal court, you're going to get federal courts building up their own system of law. There's going to be more federal common law. Federal courts are going to be consulting state judicial decisions much less. And you're talking about really eroding Erie and really eroding that basic supposition of our federal system, which is state courts do, in fact, have the final say over matters of state law. Now, Chuck made a little bit of fun. He poked a little bit of fun at Strawbridge v. Curtis. May not have been Justice Marshall's greatest decision. It's 2 short paragraphs. I miss those kind of opinions today. But it's been interpreted to say that there must be a diversity of citizenship between each plaintiff and in each defendant. We've always paid respect to decisions that were close to the founding event. Strawbridge was handed down in 1806. And it stood the test of time because Congress, in all of its different amendments of the Judiciary Acts, has never thought to overturn Strawbridge v. Curtis. The complete diversity requirement has hung in there through centuries. I think it embodies an understanding of the framers, and it certainly embodies settled understandings. I'm a Burkean by nature. I think change should be incremental. I don't believe in just turning settled understandings inside out, if I may be permitted a digression. There's a wonderful new biography of Edmund Burke by a conservative MP named Jesse Norman. Pick it up and read it. It's really, it talks about the value of experience, the value of tradition, and the litigants know the rules of these settled understandings. They've litigated under them for years. Laws are passed in reliance upon them. You have to understand what exactly are you going to be gaining by overturning this long-standing requirement, and why? Why would we suddenly want to overturn it in a time in our national life when the case for retention is growing stronger. You can understand why diversity of citizenship and prejudice against out-of-state defendants or out-of-state parties, why that was important to the framers, because they just emerged from an environment where there were 13 different colonies and they were very, very separate from one another. But that isn't true today. How many people in this country have lived in 3 or 4 or 5 states before they reach adulthood? Can we really say that the reason for diversity jurisdiction, which is a prejudice against out-of-staters, is as prevalent today as it was in the time of the founding? I don't think so. I think jurors and judges are likely to have traveled through, to have vacationed in, to lived in for considerable periods of time other states. So why overhaul the requirement of complete diversity at a point in time when I think prejudice against out-of-state parties is lessening? It's true also because many of our largest corporations have branches in different states. Wells Fargo, Blue Cross Blue Shield, they're going to have branches in every state, and of course diversity of citizenship is defined by the principal place of business and the state of incorporation. But in a practical de facto sense, these corporations are present in all kinds of states, and jurors and judges probably know somebody who works at Wells Fargo and works at Blue Cross or whatever you. So if prejudice against out-of-staters is our main concern, I ask you this: isn't it less of a danger now in our interconnected country than it was at the time of the founding? There's so many ways to lessen prejudice against out-of-staters if that's really what you're doing. If you're in state court, hire a wonderful state lawyer, someone who practices there, somebody who can walk the walk and talk the talk, and appeal to the jury as a local representative and to the judge as a local representative. You may be able to get the non-diverse defendant dismissed under under theories of fraudulent joinder, or whatever if you move promptly. Maybe the answer, if there's still prejudice against out-of-state defendants, lies in loosening the requirement of international shoe. Maybe this is a question of personal jurisdiction. Maybe it's a problem of being able to haul into particular courts people with minimal contacts, and maybe the standard should be one of meaningful contacts and have a connection specific to the case before an out-of-state party is pulled into a particular forum. But isn't it better maybe to go at some of these problems rather than taking this gargantuan step of repealing the requirement of complete diversity, to look at other avenues, such as our doctrine of personal jurisdiction? If we have a problem with class actions, well, Congress passed a targeted piece of legislation in the Class Action Fairness Act, where you have damages of a certain size and a class of a certain size and damages of a certain amount you can remove to federal court. The act isn't perfect. As you might imagine, with so many lawyers present, there's a tremendous litigation over whether the class is sufficiently numerous or whether the damages really are of a certain amount, and so there's a certain litigation over threshold jurisdiction requirements in the Class Action Fairness Act, which is not good, but by and large it addressed a real problem, which was class action hotspots in maybe in Harris County and in Iowa and in Madison County, Iowa. They became notorious. But the point that I'm making is that through personal jurisdiction and dismissals and legislation like CAFA, there's a narrower and targeted way to get at any remaining problems that exist. Maybe we should just lay it all out on the table. Isn't the subtext to this whole debate this morning the fact that some folks feel that state judges are substandard and that they want to be in federal courts, that they have a greater confidence in the quality of the federal judiciary? I'm going to speak anecdotally here, but I don't buy that. I don't buy that. We all have our own impressions. Senator Mike Lee is going to address this convention. His brother Tom Lee, clerked for me. He's now a justice on the Utah Supreme Court. You know, there are few better judges in this country. Read his opinion. It'll make you want to be in state court. And I want to speak also about my own court. On the Fourth Circuit, Steve Agee and Barbara Keenan, both on the Fourth Circuit, were served on the Virginia Supreme Court. Diana Motz and Andre Davis from Maryland served in the state judiciary. Allison Duncan, Jim Wynn, Al Diaz, and my dear departed friend Sam Irvin, all served in the state judiciary. Henry Floyd from South Carolina. I've served on state federal judicial councils and conferences, and let me tell you, from my personal experience with so many different state judges, these are terrific people. Whether you agree with them or whether you don't agree with them, they're good judges, they're conscientious judges, and they do just a fine job. So I don't buy into the notion that, as a general matter, the state judiciary is substandard. I don't accept it. Maybe it's the system we don't like, the fact that some judges in the states are appointed, others are subject to retention elections, others are subject to partisan elections. Maybe in your state you wish for some better judges. Okay, I understand that, but then go to the states and get it done. Now, yes, I understand that's harder work, that's labor-intensive work. That can be tough slogging. But it honestly is the way our democracy is supposed to function, not by simply handing over power over the states to the Congress and to the federal courts. The states can generate a kind of energy that I don't think the federal government can replicate. I'm a believer in federal court, and in federal courts in the role that we play, and I do understand the frustration that many business concerns have about facing so many different laws and so many different state judiciaries, and perhaps there are different sets of rules in state courts that make that difficult, and there are different, as I say, different laws, different provisions depending state by state. And so a multi-state corporation experiences a certain understandable frustration with the varieties of state practices that constitute our federal system. But once again, when you think about it, there really are ways of addressing the problem that I think are less drastic than the proposal before us today. For example, there were all sorts of scattershot views about pension payments and severance payments, and Congress passed ERISA, which was a national statute, and it provided a federal cause of action, and it provided a way for those claims to come into federal court. And it passed a very strong preemption provision with ERISA, which helped to mitigate the problems with varieties of state laws. So there are ways of passing substantive federal legislation coupled with strong preemption provisions that can address this particular problem as well. But I want to return to where I started, and that is to this Madisonian model that I think lies really at the very heart of our constitutional system. And what I'm going to say is probably taught in kindergarten, but it means so much to me that I hope you won't mind if I repeat it. Before the framers of the Constitution framed that marvelous, wonderful document, the whole notion was that if you had 1 acre of land, you could only have one sovereign over that acre of earth. And the French philosopher Montesquieu held that sovereignty was indivisible, 1 acre of land, one sovereign. And the genius of the Federalist Papers and the genius of our Constitution and the personal genius of Madison and Hamilton was that you could have 1 acre of land and you could have 2 sovereigns. But the genius didn't stop there, did it? Because not only did Madison and Hamilton argue for 2 sovereigns, but for 2 sovereigns of very different natures and characteristics. The one sovereign, the federal government, was to have limited and enumerated powers. The other sovereign, the states, were to have control over the residuum. That's what explains things like the 10th Amendment. That's what explains things like Article 1, Section 8. That's what explains things like the limited grant of jurisdiction. And what my friend Chuck wants to do is, I think, impair the very nature of our constitutional structure and the very nature of our federal compact. And what I urge you to do is, there may be short-term considerations of this or that, and we can address those in legislation, and you can contract diversity a little bit, and you can expand it, and you can do this, and you can do that. But to me, why I wanted to talk with my friend this morning about it is, don't take this step about abolishing complete diversity, because that just strikes at the very heart of our constitutional system. We've lived with it too long, and we love it too much to take a step like Chuck is urging today. Thank you.
Well, thank you, Jay and Chuck, for setting up the poles of the argument, and I find myself uncharacteristically in the middle. And my immediate response to Judge Wilkinson would be, I favor states' rights as much as, under the constitutional plan, as much as anybody does, but we are dealing with a subject here that is within the direct grant of the federal judicial authority. So it's not like substantive due process, for instance, which is a judge-made convention. And as I will say later on, it is an area, diversity under Erie requires federal courts to apply the substantive law of the state jurisdiction. So diversity jurisdiction doesn't really expand the federal courts. It offers a forum. It does not, it's not intended to expand the power that the federal courts hold ever since, Swift v. Tyson was abandoned, which may not have been a bad thing, but that's a topic for another day. I'd like to make about 2 or 3 points here. Chuck's article is well worth reading. It is very fascinating, and I think anyone has to pause at the argument that Article 3, Section 2 confers the judicial power on the federal courts or on the Supreme Court of the United States and such inferior tribunals with exactly the same language. It shall extend. That is used for the attribution of authority to the President in Article 2 and the Congress in Article 1. And no one would argue, I don't think, certainly not this President or recent Congresses, that shall extend does not mean the full extent of all the authorities that are enumerated within those provisions of the Constitution. So diversity cases between citizens of different states is right there in the Constitution, and we imperil it at our, we can't say that the Constitution allows a 34-year-old to become president, so why should we not be able to say that diversity jurisdiction is inherent? Now, I had thought Jay makes a much more appealing and nuanced argument for limiting diversity jurisdiction than many of the distinguished authorities that have been in this area. But let me start off with saying that I have a few questions about Chuck's thesis, because if you actually take seriously the idea that minimal diversity is not constitutional, then how can you support the fact that the first Judiciary Act had a minimum amount in controversy? Because if you take this with absolute literalism, the amount in controversy requirement makes no, is probably unconstitutional. The first Judiciary Act, 1789, also had a protection against the false creation of diversity by the use of an assignee. It also had a provision that the defendant, I think it was that act, could not remove, only a defendant could remove a diverse case into the federal courts, not the plaintiff resident in the particular state. So all those provisions would be drawn into question if you say that the conferral of diversity jurisdiction on the federal courts is absolute. I'll add a shout out here to my just graduated law clerk, Michael Toth, who wrote a biography of Justice Oliver Ellsworth for ISI, one of the lesser-known founders, but Ellsworth was a member of the Constitutional Convention, ended up as a member of the U.S. Supreme Court, and in the middle is widely credited with having written the first Judiciary Act for the first Congress. And I sent an email to Mike, who's now out at Stanford. I said, what was Ellsworth's view of the first Judiciary Act? And he said, well, there was a widespread perception of prejudice if a person from one state had to travel all the distance to another state to collect a debt, and therefore Congress believed that transactions of a certain size, which had to do with the jurisdictional limit, ought to be litigated, if desired, in the federal courts. So it is my view that diversity is subject to regulation by Congress, obviously to a certain limit, and we could have more debates over the constitutional nuances of that, but I'm not going to get into them here. Moving on to the broader question about diversity jurisdiction, I sort of naively assumed that Jay was going to take the conventional federal judge position, which is, oh, the federal courts are so busy, we can't possibly handle diversity cases. And that's the argument that's been made for approximately 100 years. The real assault on diversity jurisdiction started with the progressive movement. And one of the earliest attacks on that is a provocative article written, I assume as a case note by a then young Harvard law student named Henry Friendly, who credits Professor Frankfurter and someone else like Brandeis for having inspired him to write on this topic. And even in 1928, Judge Friendly was of the view that diversity jurisdiction was a distraction of the federal courts from their real and important business, which is creating constitutional rights, deferring to administrative agencies, or at least he could see that in the future, and so on. And he said that, he did have several memorable quotations in that article, one of which was the interesting feature about diversity jurisdiction as debated during the constitutional period was not so much the ardor of its attackers, but the apathy of its defenders. And he then sets up a couple of straw man arguments about diversity, one of which was local prejudice. I see no evidence, he says in 1928, that there is local prejudice. We are an ever more closely knit commercial republic. People travel and so on. Think of this, 1928, where there was still legal segregation, Jim Crow laws, and believe you me, with a dad who came from Texas and wore cowboy boots in his first week of medical school, and a mom who came from Pennsylvania and realized that Sinton, Texas, where Daddy was from in the 40s, still had board sidewalks on the streets, there was a bit of local prejudice. There's still local prejudice as far as those of us in flyover country are concerned. So, but the conventional wisdom among the elites in the federal procedural bar and many of the elites within the judiciary is, there's never been such a thing as local prejudice. Judge Friendly's other argument was, Justice Chase had said, as did many of the framers, that this diversity jurisdiction was essential to maintaining peace, national peace, and harmony. And think about that. That's a broad claim. And Chase went on to say in an opinion that diversity jurisdiction fostered the growth of interstate commerce. Obviously, what is this? This is what I said is the rule of law issue, because it is not simply the question whether justice in fact is better administered in a local jurisdiction or in a federal court. It is whether the appearance of justice is maintained. And this is not a defendant-only argument that I'm making. I'm talking about the fundamental economic well-being of the United States, because of course I'm a big believer in economic competition. But if investors see that certain places are not favorable to doing business, because they can't enforce their contracts, or because they are going to be subject to class action suits that cost millions to defend and enrich certain parties by millions of dollars at the questionable benefit of the consumer, they don't have to do business in those areas, even in this era of a closely internet-connected republic. I mean, why do businessmen have problems dealing in China? The rule of law is not real strong over there. Now, I'm not equating jurisdictions in the United States to what goes on in the Chinese courts, and nor am I criticizing the Chinese, lest I be, misinterpreted as I have in the past. But there is no question that you can call it prejudice or whatever, that there are certain jurisdictions and localities within jurisdictions where it is more difficult to know that the rule of law, which I described earlier, generality of application, which means fairness to all, fair procedures, transparency, and ultimately accountability are being respected less than others. And I might add parenthetically, and I'm sure Jay agrees with this as much also, there are federal district courts where those values are taken a little less, or with a different cast than some of us would.
Edith,
So, oh,
can I jump in here a little bit?
sure. We're all running over, so why not?
You've just been talking, Edith, about the places where they're prejudiced and everything. And I think if you set a hierarchy of prejudice, there is racial prejudice, there's ethnic prejudice, there's religious prejudice, there's class prejudice. But I'm not sure in the hierarchy of prejudice how high prejudice against out-of-state parties ranks. I think that one of the real prejudices in the judicial system may be with respect to size. Well, this is a big company, and we're going to sock it to them. But prejudice on the basis of size or deep pockets is different from prejudice against an out-of-state party, because the prejudice against size and a deep pocket can persist even if that entity is in state. So I'm not sure this gets at the real problem, the change in complete diversity gets at the real problem of prejudice on the basis of size and assets that may exist in the judicial system. That's what I don't think it really addresses that. And there's one other point that I do feel is important to respond to what Chuck has said. Chuck has
Are you calling time on me?
What's that?
Are you calling time on me?
No, I would just like to respond to Chuck. Because I know Chuck, and he's going to land the last blow. He will.
Well, I haven't landed my last blow yet. And my last blow isn't really so much against your position, because I think there's a great deal of strength to the idea that we take issue with Chief Justice Marshall at our peril. And, it's easy to say that someone 9 years dead would have come out the other way. I mean, it's easy and it's risky. So which is why I took on the broader arguments that are conventionally made against diversity jurisdiction in general. And I just want to mention one other thing, though, because I am not criticizing state courts in general as such, and I know there are state court judges in this audience whose comments would be appreciated if we even have time for that after we land our blows. But if you'll wait, one other point is that handling diversity cases is a very stimulating part of the federal docket. Again, contrary to what some of the elite commentators in the past have said, diversity puts us in the position of being real judges, judging real law for the most part. And I somewhat disagree with Jay's point here that we'd be sailing off into new territory and creating vast new seas of law under diversity with an expanded diversity jurisdiction. Just to name a few of my recent ones, they had to do with an easement on the Mississippi River, the terms of financing, long-term, partly state-issued bonds for a major investment, questions about state tort responsibility, as I've mentioned. These are not inconsequential issues, and they draw federal judges, and as a subsidiary point, our law clerks, back to real law, because when you're interpreting statutes, if a statute is vague, you're operating in a pretty much of a logical vacuum. When you're interpreting the Constitution, We're dependent on what 9 members of the Supreme Court have said and what we think they might have said or might have been thinking. And again, it is not the same thing as the concreteness of the common law that decides so many state controversies. So I would say it's a good thing to maintain a sense of reality and discipline among federal judges ourselves. And again, bringing it back to this Class Action Fairness Act, that's been criticized by plaintiffs' lawyers who deal in class actions. But on the whole, and I agree with Jay that there have been various problems about it, its implementation, but the purpose was to bring these kinds of controversies that in the present day are typically lawyer-driven into the federal courts when they have a certain minimum level of national import. And whether it's achieving that position adequately, those goals adequately, I'm not in a position to say at this moment, but I would say that in response to doing away with minimal diversity, which the courts are not likely to do, certainly Congress can address these kinds of issues to ensure that cases at least of a certain variety remain, that have a national cast, arguably, are in the federal courts. And with that, I will let Jay land the penultimate blow and Chuck land the last blow and maybe a couple questions.
Chuck, you haven't had a chance to speak yet. I think you should have. I think you should go ahead.
And that suggests to me, Jay, that you want to reserve the last blow for yourself. Well, I would like to say a word or two in response to Jay's very powerful rebuttal to my points, his rebuke, really, in some respects. And I respect it very much. And he's identified some areas of really profound agreement that we have. No one, I think, is more wary or resistant to the idea of any kind of wholesale shift of power from the states to the federal government, particularly perhaps to the federal judiciary, than I am. I've been a thorn in the sides of the tort reform advocates for 30-something years now. Charles Freed is our former colleague and dear friend, former Solicitor General, as Jay well knows, in his tell-all book called Me, the Reagan Administration's Federalism Cop. And it was very, very true. I very much have opposed all manner of preemption ideas, the idea of substantive due process, Judge Jones somehow restricting the size of jury awards and state court actions, those kinds of things. But and I will frankly admit, I came to this project with some real skepticism. But once I dug into it, not having done it, since law school, really, it became clear to me that this was that diversity jurisdiction, not complete diversity jurisdiction, but diversity jurisdiction as written, was the vision of the framers. This is what they had in mind, and it was of a piece. It was of a piece with the Interstate Commerce Clause. It was of a piece with the Contract Clause, which prohibited states from destroying the obligation of contracts. It was of a piece with the Privileges and Immunities Clause, and it was captured. I mean, this was all a tapestry. These provisions, which allowed the federal Congress to, in fact, invade the sovereignty of the states, were to be coupled with a neutral federal tribunal to encourage that very kind of national commercial union that those substantive provisions were designed to ensure, despite what were very real parochial policies. Here's how Wilson put it in Pennsylvania. He saw diversity jurisdiction as necessary to achieve what he called the important object of extending our manufactures and our commerce. This cannot be done unless a proper security is provided for the regular discharge of contracts. The security cannot be obtained unless we give the power of deciding upon those contracts to the general government. So my very deep, instinctive, reluctance or skepticism about things federal has to give way to to the truth of my eyes as I read the original meaning of these provisions.
If we're going to have any time for questions, do you want one more?
Yeah, can I
And then we'll,
briefly come back, Chuck?
Sure.
Okay. One of the things that concerned me most about your article, and you wrapped yourself in Joseph's story, and that's, pretty respectable company. And I understand where you're coming from, but you're suggesting that minimal diversity, you and Justice Story are suggesting that minimal diversity is constitutionally compelled. And I just don't agree with that at all, because I think what you're doing, there are two problems with your argument. Number one is you fasten on the words, the judicial power shall extend, to say the Constitution, that this is minimal diversity is constitutional compelled. But that takes just two words out of it, and you've added the whole judicial power shall extend. And that's not what the provision in Article 3, Section 2 says. And the other thing I think you've overlooked is the ordain and establish clause in Sheldon versus Sill, which gives Congress the right to establish federal jurisdiction with such exceptions as they may make. And my whole plea to you is, please don't try to constitutionalize this. Let's at least agree on leaving it within the realm of the statute, and let Congress contract or expand jurisdiction at the margins. But I really was concerned about trying to constitutionalize a rule of minimal diversity. And the other...
May I now interject?
Judge?
Judge?
I think the audience ought to have a chance here for 5 minutes or so.
So long as I still get the last word.
Picking up on Judge Wilkerson's comments about fraudulent joinder as one of the things that could be dealt with, the typical situation is that the real defendant is an out-of-state corporation. The plaintiff joins an employee or independent contractor to prevent removal. What would you think about a statute designed specifically to address that? For example, borrowing from CAFA the idea of the primary defendant and saying as long as the primary defendant is a non-co-citizen, the case can be removed.
He said, what would you think of a statutory amendment to fraudulent jurisdiction a la CAFA, which said the primary defendant?
That's exactly the kind of approach that I like, because it's targeted. And there is a problem with fraudulent jurisdiction law as it exists today, I think, and that is that you have to establish that the joinder of a non-diverse defendant is totally ridiculous, and that there's no possibility of ever recovering, that it's a sham, that it's corrupt and everything. That's very hard to do. And so I think making the fraudulent joinder law a little bit more realistic, which is what you're suggesting, something like that appeals to me, because it seems to me that the kind of intermediate step that addresses some real problems. It's an interesting thing. A lot of people have said, oh, diversity, the complete diversity rule is so unfair because it gives the plaintiff the choice of forum, and it essentially prevents removal by the parties that the plaintiff selects. And, you know, there's a question about that because the party that initiates the suit always has a choice of forum, but I understand that concern. I really do. And I like your question because it really seems to me to hone in on one of the problems here, which is that fraudulent jurisdiction, the bar is so terribly high.
This is an area of, again, profound agreement that I have with Judge Wilkinson. My purpose isn't certainly to constitutionalize minimal diversity, even though I believe Justice Story advanced a very powerful case. I recognize, and I mentioned from the outset, that it is a close question. Judge Jones has pointed out, and you have pointed out, very strong arguments on the other side. That's a close question. And it seems to me that reforms of the complete diversity doctrine can very meaningful reforms that could address some of the abuses that take place could happen without completely overturning complete diversity and adopting absolute minimal diversity. This suggestion is certainly a very good one. Keep in mind that all of these doctrines that have encrusted on this, born in error doctrine of complete diversity itself are all judge-made. The presumption against removal, the very huge hurdles that Judge Wilkinson has identified that the federal courts have required to demonstrate a fraudulent joinder, those are all judge-made. Those are active efforts by the court that can't be explained in any other way, that they don't want these damn things in their courtrooms. They don't want these cases in their courtrooms. Well, that's just absolutely not consistent with the vision of the framers of the purposes of the diversity clause.
All right, next question, please.
Yes, Judge Mary DeGennaro, and I sit on an intermediate court of appeals in Ohio. I have two quick comments and then a question. I appreciate Judge Wilkinson's candor in bringing up a delicate issue that underlies this debate. I think your comments and Judge Jones' comments reinforces your point, that being there is a broad spectrum of judicial philosophy and analysis. So I think it's not exclusive to either the federal or state bench. My other comment is there is a vast array of how state judges are selected. And another frank comment I would make is the federal judiciary is also subject to a campaign of sorts, but their voter pool is much more smaller and their terms are just a tad longer than ours. So I appreciate that and be mindful. And your point about the hard work of making sure that good judges do stay on the state courts. I mean, I come from a part of the state of Ohio where I am in the minority party and was able to survive elections. And the public do understand the difference between judicial races. So I appreciate your defense of the state judiciary. My question is, my observation is Chief Justice Marshall and the early court favored unanimity in their opinions. And my question is, when Strawbridge was decided, were there any Jefferson appointees on the court? And what was the regional makeup of the court when that issue was decided? And could that perhaps impacted why it was decided in the manner that it was?
You did the history.
I hate to say it, but my memory doesn't bring that answer immediately to my mind. And my partner, Howard Nielsen's not right here, as he normally is, to provide me with the answer. So I'm afraid I'm just going to have to kick that over, hopefully, to my more learned colleague. I would like, however, to say that I welcome very much the comments that were just made. And I want to resist the notion that as we put our cards on the table, that the real issue here necessarily is that the state judges are substandard. I think that is certainly not a statement that I embrace or that I want to be associated with. What I do believe is a very real problem, however, is that there are some state jurisdictions that have been actively corrupted. I don't know any other way to put it, by lawyers who are not adhering to the highest standards of our profession. And we see this in Judge Jack's disclosure in the asbestos litigation of the kinds of fraudulent evidence that's been invented and put before cases in the asbestos area. It's a number of these things, and these things are not, these aren't imaginary. These abuses happen, and why the judicial involvement in those abuses, I guess, depends from case to case. Maybe it's just because the judges aren't paying enough attention, but they happen, and that's the real difficulty, and that's why these cases are being herded into particular jurisdictions.
I don't want to cover, I will have one quick question. Person at the back, please.
Good morning. I was interested in the discussion we've had about the constitutional requiring an exercise of jurisdiction in cases involving parties from different states. And I shared Judge Jones's question about what that means for the amount of controversy under 1332 in CAFA. So I was wondering, Mr. Cooper, if you could just very quickly address that, and especially if it concerns you, being that the amount in controversy was in the 1789 Act.
I'm sorry, I only heard the last part of your question.
He said, was the amount in what do you respond to my point about the amount in controversy being part of the 1789 Judiciary Act?
Yes. No, it's a very powerful point. Certainly as I say, this is a close question. The first Congress's legislative activity, fresh on the heels of the ratification of the original Constitution, is very, very powerful evidence of what the Constitution was intended to mean. I get that, I accept it. I rather think, however, that and we deal with this in our article, and if you want to really dig into this issue, please take a look at it. But I rather read that history as along these lines. The Anti-Federalists came to the first Congress seeking to amend the Constitution in a lot of ways. The Bill of Rights grew out of that, obviously, but they also sought to amend Article 3. One of the ways they tried to amend it was to include a minimal amount in controversy. I think it was $3,000, and it came from Ellsworth, I guess, one of them.
I don't remember.
But they failed in getting the amendments passed to Article 3. The Federalists won across the board. Maybe one of the reasons is that they promised them a statute that did the same things. I rather think that is likely the political dynamic at the time. But whether it is or not, it is very hard to square a minimal amount of controversy, I admit, with a reading of the plain text of the Diversity Clause.
Judge Wilkinson, you get the last word.
Mine will be very brief. This has been a lot of fun for me. I really relish any chance to be on a panel with Edith and Chuck. And one of the things that makes the Federalist Society so great, at least in my view, is where else would you ever find so many people at 9 o'clock on a Friday morning this engaged with the more arcane aspects as well as the larger picture of diversity jurisdiction. I mean, this is really, to me, one of the things that makes the Federalist Society so great. You're interested in ideas even at 9 o'clock. So thanks. It's great to be on a panel before such an audience.
I yield the last word to
There you go.
to my friend from Virginia.